patent attorney in our advanced engineering group. Chris is also based in the UK and specializes in manufacturing engineering, with a special interest in aerospace and medical devices. Chris is on our China desk and travels regularly to China, and you may well have met Chris before on one of our trips. I'm also joined by Mark Caddle, another partner based in the UK, specializing and qualified as a trademark attorney. Mark has a legal background and also frequently visits East Asia. I'm also joined by Simone Schwärzer. Simone is a paralegal, German and UK IPO qualified, based in our German office in Munich. She'll be discussing paralegal perspective on the changes to the IP landscape in Europe after Brexit. So they will now take you through our presentation and the things you need to know about intellectual property rights in Europe after Brexit. I said breakfast there. Must have breakfast on my mind. I meant Brexit. I will now hand over to Chris.
Thanks, JP, and good afternoon, everyone. So this is just a quick comment on invention patents. So the main headline is that there is no effect on European patents due to Brexit, and that's because there's no change to the European Patent Convention, which is unrelated to the European Union. Therefore, Withers and Rogers can continue to prosecute your direct European applications and your PCT applications. We are also able to handle your direct national filings in the UK, France, and Germany. And that's it, short and sweet. So I'd just like to pass on to Mark.
Thank you, Chris, and thank you, John-Paul, for your introduction. Today's session will focus mainly on EU trademarks and designs and how they are affected by Brexit. What we will aim to cover is what EU rights holders should be doing now to ensure their European IP is still covered post-Brexit. And also we will highlight what you need to do from now on since January 1, 2021 to avoid any loss of rights and get the best from your European IP portfolio. We will also highlight the key differences between EU and UK trademarks and designs. First of all, a recap. As of 1 January 2021, the United Kingdom is no longer a member of the European Union. And this has an impact on the effect of EU trademark and design registrations. As we can see from the map on the slide, the countries in blue are members of the European Union and are covered by European Union rights for trademarks and designs. And as you will see, the United Kingdom is in grey. It no longer benefits from membership of the European Union. Today's session will outline and highlight why this is important to you and why you need to think about Brexit's impact on your IP portfolio, particularly in relation to trademarks and designs. As Chris said, patents are unaffected by Brexit. For any new EU trademark and design applications that are filed as of today, they will no longer protect the UK, and separate UK applications for trademarks and designs will be required to give you the same protection as what EU applications could give you previously and before Brexit. One thing that I should mention is that for any new applications that are filed at the UK IPO from 1st of January 2021, there will be a requirement for a UK address for service. Previously, it was possible for an address for service to be in the European Economic Area, so an attorney from a member state of the European Union, for example. But from now on, UK IPO will no longer accept those addresses for service, and you will need to have a UK attorney represent your clients before the UK IPO. And as John-Paul said, we are a European firm. We will continue to handle UK and EU applications and renewals for our clients. So nothing changes for how we can act for you and represent your clients in Europe. And one thing I should also mention is that from 1st of January 2021, dual filing in both the UK and the EU will be required to obtain the same rights for trademarks and designs as what EU registrations could give you previously. So there are two scenarios that I wanted to highlight to you. The first of which is dealing with how Brexit has impacted EU registered rights, so trademarks or designs that have been fully registered and published as at the 31st of December 2020. As I said previously, as of the 1st of January this year, the UK is no longer a member of the European Union, and there have been laws put in place to make sure that there are no rights lost as a result. So for any registered rights, the scenario is nice and simple. The UK IPO has automatically created what is called a comparable registration of your existing EU trademark and design registrations, and those cloned registrations have already been added to the UK register. So you have an automatic separation of the EU registration. It will continue in force in the other European Union member states, but not in the UK, and a new separate independent UK registration has come into being, and this can be enforced, abandoned, licensed, transferred, or renewed as you wish, and completely separately and independently from the EU registration. And this has happened at no cost. The UK registrations are live now, and you can access the UK IPO records to find the new UK registrations. So this has already happened, and the registrations in the UK are now live. Things for you to consider. As I said, no action is required. The new comparable registrations or cloned registrations have been created at no cost. They are already on the UK register. So it would be useful for you and your clients to ensure that the new registration details for the new UK registrations that have come into being are docketed properly for your records management and for any renewals that you need to monitor. Of course, we can share with you any information that you need from the UK IPO to help complete your records, and as well as that, we can supply any information you require from the EU IPO to assist with this. One thing I should mention, the UK IPO has not issued new certificates of registration for the new UK InDesign registrations. The information can be accessed on the UK IPO records, but there is no new certificates being issued to trademark and design owners. Our records, though, have been automatically updated to include the newly created UK registrations in our clients' portfolios. So if we handle any EU registrations for you, design or trademark, we will already have for you the details of the cloned comparable UK registrations. Now, if you or your clients do not want the automatic cloned registration, there is a mechanism for you to instruct the UK IPO that you do not want the new registration. If that applies, I would suggest that you contact us and we can advise you further. One other thing that I should make you aware of is that for the new comparable registrations, a new numbering system has been introduced by the UK IPO, and this information is already available on the UK IPO website as of the 1st of January. For existing EU trademark registrations, The new comparable UK trademark is the last 8 digits of the existing EU trademark prefixed with UK 009. An example is on the slide. And similarly, for existing EU designations of international trademark registrations, so any EU designations that have been obtained via the Madrid Protocol, it will be the last 8 digits of the international trademark prefixed with UK 008. Again, an example is on the slide. Likewise, for designs, any existing registered community designs, the new numbering is the full 13-digit registered community design number, prefixed with the number 9. Again, an example is on the slide. And should your client have any international design registrations in its portfolio, EU designations of those registrations will be prefixed with the digit 8. Again, we've shared some examples on the slide. So these are things to bear in mind for updating your records and perhaps advising your clients should they have any questions about the newly created UK rights as a result of Brexit. The second scenario, which has a different effect, which requires action from you and from your clients, is where, as at the 31st of December 2020, you are the owner or represent a client who is the owner of a pending EU trademark or design application, which has been filed but not yet fully published and registered as at the 31st of December. Now, this scenario has a different effect to the registered rights scenario I explained previously, and it needs to be managed in a different way. For EU applications that proceed to registration after the 31st of December, assuming they were filed at some point in 2020 or before, that EU application will only obtain registration in the EU member states that continue to exist, so the 27 member states which exclude the UK. That EU application will no longer cover the UK, so the registration will have no effect in the United Kingdom. However, for those applications which are pending at the 31st of December 2020, you have the option up until the 30th of September 2021 to file an application for an equivalent UK trademark or design which would replicate the EU trademark or design application in its entirety. So essentially, you would refile for the same trademark in the UK, and it would keep the same details as the existing EU trademark, which was pending at the 31st of December. And to benefit from the same dates, priority dates, filing dates, the application in the UK must be filed by September 30, 2021. As we said, Withers & Rogers can continue to represent you and will continue to represent you in relation to the EU part of the registration process for trademarks and designs, and we can also provide the UK refiling service for you. And it also follows that we can also handle any future EU and UK registrations that are required without you having to change the way in which you interact with our firm. A few notes on the logistics of pending applications. As I said, by September 30, this is the date that you should docket for your clients. This is the date by which any EU applications that need to be refiled in the UK must be filed. And we can action these instructions for you, as I said. And to do that, we would need from you details of the pending EU application to assist in making the new application at the UK IPO. And we will show you some examples of the UK IPO's forms and the information that we will need later on in the webinar. And one thing that I should also mention is that the normal UK IPO filing fees will apply for any new applications that are required ahead of that deadline. So, as I said, for registrations, there is no cost. We are not incurring any costs for clients by taking those newly created registrations onto our records. But for filing new applications to satisfy this deadline, we will be required to pay the UK IPO official filing fees and professional fee for our firm for handling those applications, and we can provide you with more information should you require it. And as I said before, all refiled applications at the UK IPO will require an address for service in the UK. So if you have a pending EU application that is being represented by a firm based in the European Union, that firm will not be able to handle the UK refiled application for trademarks and designs at the UK IPO. A UK-based representative will be required. I should also mention that for any EU designations of an international trademark, for example, the right that would be created is a national UK registration, and it is not a new designation to the international registration under the Madrid Protocol. So if you have any clients that own Madrid Protocol registrations that designate the EU, if they are registered, a new national UK registration will come into force, or has come into force, and that will be separate to the international registration. It will require its own management and its own renewal, not part of the international registration. And as I said, the new applications will continue to have the same filing dates and priority dates as the existing pending EU trademark or design applications. To reassert our position on how we can help you, we can work with you to provide IP protection across Europe as a whole. As we said, we have offices in London in the UK, Paris in France, Munich, Germany, and we can represent you and your clients before the UK IPO, the French and German patent offices, the European Patent Office, and the EU IPO for trademarks and designs. So the way in which we can assist you has not changed because of Brexit. We continue to be a European IP firm. I have a couple of slides on some more technical aspects to Brexit, some things to bear in mind for you and your clients, which may help their strategy for the EU. The first of which is what we call customs notices. Now, this is a mechanism whereby you can protect your client against infringement of its intellectual property rights on any imports that come into or leave the UK and the European Union. The way in which to do this is to have your client record via a firm like ours their IP rights at the UK and EU customs authorities. The customs authorities then act as a guard of the border, essentially, in the UK and the EU, and will advise us if any infringing products or what appears to be infringing products are seeking to enter the UK or European market. We can then advise you, and you can instruct your client that this has occurred. And one of the remedies could be that any counterfeit products that are entering the UK or European market, which are counterfeit, can be destroyed and the infringement will cease. As with most things related to Brexit, the EU and the UK now needs to be considered separately, and the EU customs notice, which would apply in the European Union member states, no longer applies to the UK. So if your client did have an EU customs notice in place, it would be worth taking advice on whether a UK customs notice, which we call an application for action, is required in addition to the EU customs notice, which is already in place. Another more administrative issue is for any recordals that have been filed against an EU trademark or design. For any licenses or security interests which have been recorded against an EU registration, there is a deadline of January 1, 2022 for those to be recorded against the new cloned UK registration. So if in your client's portfolios of EU registrations, there are licenses, for example, recorded against the registered rights, it would be prudent to have those recorded in the UK by January 1, 2022. If this does not happen, those details will not be recorded against the comparable UK registration. And also, if your client instructed transfer of ownership and assignment of its EU registration, and this was pending at the end of 2020, it would be worth checking to ensure that the new UK registration has benefited from that transfer of ownership. If the transfer of ownership was not completed at the EU IPO by the end of 2020, the new cloned comparable UK registration will appear in the old owner name, and therefore it would be useful, prudent for your client to ensure that the UK registration is in the name of the correct owner. So if you're aware of any instances of pending assignment recordals at the EU IPO, please let us know and we can assist to ensure that the UK registrations benefit from that recordal of transfer of ownership as well. I mentioned the creation of new separate UK registrations, and I'm sure you'll understand the logic that those new UK registrations will require their own renewal separate to the EU registrations. So for your clients, it is prudent to ensure that any new renewal dates are docketed by your firm. We will docket those dates if the EU registrations were under our management, and of course we can help with any new comparable registrations should you require it. And if the UK registration, design or trademark, which has been cloned, does not get renewed by the relevant deadline, the UK registered rights will be lost. The EU registration, which will require its own renewal, that will be renewed if you do renew it, and it will have no effect in the UK. So the UK must be renewed on its own. One technical point is that you can renew an EU trademark 6 months early, which means in theory you could have paid a renewal fee to the EU Trademark Office in 2020, and the EU registration would be renewed, and at that time that would have covered the UK. But the decision has been taken that for any EU renewal dates which are after January the 1st, 2021, a separate renewal fee has to be paid to the UK IPO, even if you took advantage of the 6-month early renewal period. So if you had paid and instructed a renewal at the EU IPO before the end of last year, that renewal will not have affected the UK cloned registration, and that UK trademark or design registration will need its own renewal date, and that that date will need its own action. And the other thing to bear in mind is that for any renewals that fall due at the EU IPO and the UK IPO, we can handle those for you, in that we are able to instruct renewals as we are new applications at both the EU IPO and the UK IPO. So bear in mind the renewals that are required for UK registrations. On pending trademark opposition and cancellation proceedings at the EU IPO, for any actions that were pending at the end of last year, which were based on UK rights, so previously it was possible to oppose an EU trademark application, say, on the basis of an earlier UK right. If an action relied on UK rights only, and not, say, an EU trademark, but only a UK trademark, those cases will be dismissed. The EU IPO will not take a decision on those cases and have already begun writing to opponents in this scenario, which we actually have cases that fall into this situation here, and we have received notifications already to say that the case has been dismissed. So if you are aware of any clients that have cases like this pending, that were pending, sorry, at the end of last year. Please do check to make sure that you're aware of this, and if you need any assistance, please do let us know. For any pending oppositions that you may have against EU applications, if a new comparable UK trademark application is filed by the end of September this year, your client may wish to also oppose that application in the UK. Therefore, you should understand whether or not there will be action required against any comparable applications that are made, which may replicate the proceedings that you did have at the EU IPO, which could continue to their conclusion if there are grounds of opposition in the EU, but you should make sure that the UK action is also taken. And any cancellation actions that have been filed against an EU registration will be honoured by the UK IPO. So if there is a cancellation action for non-use, say, against an EU registration, and the EU finds that that registration hasn't been used, the comparable UK registration will be cancelled as well. However, one of the things to be aware of is if it's an EU designation, that requires a new action. So if you have EU designations which are being attacked at the EU IPO, those will need a new action at the UK Trademark Office. I appreciate this is a technical point, and if you require any clarity on this, please do let us know, and we'd be happy to advise you further. And if the cancellation doesn't have effect on the UK, so say for example the cancellation action is based on an earlier registration which is based in Germany, that has no effect in the UK. A German registration does not impact the UK market, and therefore that cancellation action may cancel the EU trademark, but it won't cancel the comparable UK registration. And for any proceedings that are required at the EU IPO, from now on, a representative in the EU is required. And as we've said already, Lewis & Rogers can continue to act for you at the EU IPO and UK IPO, so nothing changes. On UK trademark opposition and cancellation proceedings, so the sort of reverse situation at the UK IPO, those which are pending at the UK IPO based on EU rights, they will continue to their conclusion. The UK IPO will simply update their records to replace the EU trademark registration number with that of the comparable registration. So those will continue as they were. So just bear in mind that if you have any pending oppositions at the UK IPO, to check to make sure that the EU registration number is updated to the UK registration number, but this is happening automatically at the UK IPO. And if you are relying on a pending EU application against a UK trademark application, say, you will need to file the comparable UK application by the September 30 deadline this year to ensure that that opposition proceeds. So you will need to make sure you have an earlier right in the UK to rely on. Again, these last two slides have been technical in their detail on contentious proceedings at both the UK IPO and the EU IPO. And if you have any questions, please feel free to contact us and we can steer you further. I wanted to highlight some of the key differences between the UK and EU trademark oppositions. We often get asked questions about the differences, and it's quite helpful to be able to outline these to you now. At the UK IPO, in contentious proceedings like trademark oppositions, the favoured approach is for hearings to take place, where the parties attend in person and argue orally about their case. Each party can advance their spoken submissions to the hearing officer, and a decision will be taken. Whereas at the EU IPO, as you may appreciate from your experience, everything is done on paper. Arguments are written, and there are no oral proceedings where the parties can speak their cases to the EU decision makers. So please bear that in mind. The UK proceedings can be more lengthy because of the requirement for hearings, but if neither party wishes to have a hearing, the case can proceed with written arguments only. For opposition deadlines in the UK, 2 months is the opposition period, and that's extendable to 3 months. At EU IPO, there's a non-extendable opposition deadline of 3 months. So a slight difference there to bear in mind. For any evidence required in proceedings at the UK IPO, we require what we call a witness statement, which is a written document from someone within the trademark owner's business to say why they are making the claims they are. So say, for example, you are filing an opposition based on reputation in the UK market, and you need to advance invoices or advertising efforts in a witness statement. That will be required at the UK IPO, and we require a statement of truth, which means that the document is verified by the person signing it, that everything contained in that document is factually correct. So that can be quite a burdensome task at the UK IPO, compared to the EU IPO, where there is no requirement for evidence to be submitted in a witness statement. It can be attached to written arguments without the formal statement of truth, like I mentioned, and is a bit less formal than the UK proceedings. So it's worth bearing that in mind. At the UK IPO, there's a fast track opposition. At the EU IPO, there is no fast track opposition proceedings. So in the UK, you can often get an opposition through to its decision a lot quicker. But if you're relying on a trademark that is more than 5 years old, any use evidence to prove that the trademark has been used in the last 5 years needs to be filed at the beginning. So rather than being requested by the other side to file that evidence during the proceedings, you would need to, at the time of filing the opposition, which bearing in mind there's a 2-month deadline for doing so, that can be something that is worth bearing in mind due to the work involved in having the evidence gathered prior to the opposition being filed, and perhaps also a witness statement being required prior to the opposition being filed. In the UK, we have unregistered trademark rights, which we often refer to as passing off, which you may have heard of. And you can rely on those rights in opposition proceedings in the UK, which is helpful if your client does not have a registered trademark but has used its trademark in the UK market. At the EU IPO, it's more difficult to rely on on unregistered rights, because it depends on the local law of the EU member state. So if you've used a trademark, and again, I'll use Germany as an example, if you have used the trademark in Germany but no registration there, then it'll be German law that dictates whether or not you can rely on the unregistered trademark rights that are granted in the German market. And finally, the UK IPO has very limited online records. It essentially lets you know on their website trademark and design name and what is claimed and who owns the trademark. Very basic information, but from your experience, you may be aware that the EU IPO has a much more accessible online platform where you can retrieve documents if you have a user account, and you can see more information about a particular case. So the UK IPO has some catching up to do insofar as its user friendliness is concerned. We thought it would be useful to show you a UK trademark application form to give you an idea of some of the information that's required. Here we have the form TM3, which is the application to register a trademark. One of the things to bear in mind is that a country of incorporation is required when filing a UK trademark application. In your case, China, for a majority of clients that you may act for. Also, one thing to bear in mind, there's a difference between the UK and the EU system, is that in the UK you can have a series of up to 6 marks in any one application. So you can claim 6 different trademarks in one application, so long as they do not change too substantially. The differences must be small. And the way that we tend to use this is for different colour versions of the same trademark. The example on the slide demonstrates that. So we often find this is quite useful if we have clients that would use different versions of the same trademark in different colours. I'm just reloading the slides because someone has taken control of them. So the forms are very straightforward for you to review and see the information that's required. So we often find that the series applications are something we're asked to do in the UK different to the EU. On the next page of the application form, here we have an example of where you include information about comparable EU applications or EU designations of Madrid Protocol applications. So this is where you tell the UK Trademark Office that you're relying on a new application that is based on a pending EU application at the end of last year, like the scenario number 2 that I discussed to you earlier, described to you earlier. And of course, we can enter priority claims in the UK. So if your client, for example, has an earlier Chinese application they wish to claim priority from, that is possible in this particular form. And again, we would include the pending earlier EU application details if we are looking to take advantage of the cloning system, like I mentioned before. And finally, one of the things to bear in mind is the top arrow here is for a pending earlier EU designation, so the same logic applies that we were looking to have a comparable application filed in a pending EU designation. But the thing that is different to the EU and is actually quite unique to the UK is that when an application is filed, the trademark owner must confirm that it has what we call a bona fide intention to use the trademark, which essentially means that at the time of filing the application, the owner must state that it will use its trademark in the UK. If there is no intention to use the trademark in the UK at all and an application is filed, it could later be cancelled on the grounds of bad faith, that there was no intention to use the trademark at the time it was filed. So please bear that in mind for any UK applications that are required. I will now hand you over to Simone, who will talk to you about the EU application process.
Thanks, Mark. I think the presentation just went down again.
Let me share that now.
Yeah, on the right-hand side, you can see part of the online filing form of a European trademark application. And if you want to claim priority, you have to add the country of the first filing, in this instance, China. And you also have to add the date of the earlier filing. You also have to provide a priority certificate, and the deadline for filing the priority certificate is 3 months after the trademark filing. For European trademark applications, you have to select 2 languages. The first language is for the correspondence, and the second language is for the correspondence in possible opposition matters. And this has to be one of the official languages of the EU IPO. You have to select the kind of trademark, so you can file for a European individual mark, a EU collective mark, or a certification mark. If you want to protect a 3-dimensional shape, for instance, for packaging or containers, you can file a European shape mark. Here you can see some further trademark types. So you can apply for a sound mark, for instance, or a pattern mark. It is possible to request for a national search. So if you want to have a search report from the German Patent and Trademark Office, for instance, you can do that, and you have to pay an additional fee for that, but this is optional. And it is also possible to request for a European search report. This is also optional and free of charge. And now I'm going to hand back to Mark, who's going to talk about designs.
Thank you, Simone. First of all, I thought it would be useful to highlight some of the key differences between UK designs and EU designs. First of all, on disclaimers. In the EU, disclaimers are not available, and in the UK, they are available to limit part of the protection that you are requesting for your client. So bear in mind that in the UK, the system on disclaimers is different to in the EU. And for multiple design applications in the EU, those must fall within the same Locarno class. Multiple applications are possible, but they must fall within the same Locarno classification. But in the UK, you can file a multiple design application in different Locarno classes. The deferment period in the UK, where you defer publication of the design, can be deferred for up to 12 months. In the EU, that period is for 30 months. So here we're just setting out some of the key differences for you to know on the ins and outs of EU and UK design registration. The renewal fees for UK designs are due on the anniversary of the registration date, so the period that runs from the date on which the design is registered. Whereas in the EU, the calculation is slightly more complex, and the fees are due at the end of the calendar month in which the anniversary falls from the filing date. So the renewal period of 5 years to the end of the calendar month from the filing date. The grace period for late renewal fees is 6 months in both, so that's the same, easy to remember. And for representations in the design, there's 12 allowable in the UK, and in the EU IPO for design registrations, that's 7. So like before with UK trademarks, we'll just have a quick look at the UK design forms to give you a flavour of what is required. So even if you file a multiple design application in the UK, each design will get a different application number, which puts some burden on you and your docketing system to ensure that every number is captured. If you ask for immediate publication, the process is quick. They'll generally be published within 2 to 6 weeks from the filing date. And as I said previously, publication and registration can be deferred up to 12 months from that filing date, and there is no additional fee for immediate publication. For the design itself, you have to specify a title, so essentially a short description of what the design is. You can also add a description, which can help explain the protection that your client seeks. This is optional, but can be helpful to state to the UK IPO and the world generally what the design protects. And as we said before, it is possible to describe any parts of the design that are to be disclaimed, and that can be visually or in writing. An example of a written disclaimer is on the screen at the slide. You can use up to 12 representations for a design application, and they can be provided in JPEG, GIF or TIFF format, and they can also be format, which is generally the same practice as at the EU. Example is on the screen. But one of the things to bear in mind is that the representations of a design, if more than one are filed, they need to be in the same format. So you cannot file for line drawings, but also include photographs or CAD drawings. The actual format must be the same. I'll hand you back to Simone now to discuss EU design applications.
Thank you, Mark. Just gonna head on. The number of designs in a multiple application is unlimited. You can have 7 views per design protected. You can add more views, but they will not be protected. For your Locarno classification, you can either search or browse for it, or you can enter your own terms. Yeah, it is possible to delay your publication of your application for a period up to 30 months. It is possible to add a description, but this is not mandatory and not examined, and the description can contain a maximum of 100 words. Here you can add your designer's information. However, the designer has the right to waive his right to be cited in the register. Also for European design applications, you can add a priority. You can do that when filing the application or within a deadline of 1 month. If you have displayed your design on an exhibition, you can claim for an exhibition priority, and you can do that when filing or within a deadline of 1 month. You have to indicate the name and the date of the exhibition, and also provide exhibition documents, and those can be filed within a deadline of 3 months. Now I'm going to hand back to Mark.
Simone. That is the bulk of today's webinar concluded, but before we finish, I thought it'd be worth sharing with you some practical tips on how to approach the UK and EU trademark and design registration processes. One thing we should mention is that shapes can be protected as both designs and trademarks in the UK and at the European Union IPO. The reason why this is attractive is that for designs, the protection is not limited to specified goods and services. So the scope of protection is generally wider, and it's often a good way to complement trademark registration. So please bear that in mind and ask for any advice should you require it. To recap on the Brexit implications, dual filing and renewal is now needed in the UK and European Union, which also includes any designations that you may make via the Madrid Protocol for trademarks. So please now think of the UK and EU as being totally separate. And perhaps previously where you would only file an EU design or trademark application, please be aware that to get the same protection as you would have done last year and before, you need to also include the UK separately. And of course, for new filings, that requires additional fees and additional renewal fees to maintain those registered rights later in time. So if you have any questions about that process and how we can help, as we've said, we can handle both EU and UK matters for you and your clients. Please do let us know. One thing that's worth monitoring is for any new comparable UK trademark applications that come into force, which your clients may be opposing at the EU IPO against their parent EU trademark. Appreciate that's a technical point, and if you need any assistance, again, do let us know. But it would be worthwhile ensuring that any UK rights that are sought are also challenged on the same basis as at the EU IPO, should your client have an interest in the UK market. 2 deadlines to note, the first of which is January 1, 2022. And this is for where you need to record any licensing or security interests at the UK IPO for the comparable registrations that have come into being. I described this process earlier, but something to bear in mind. Likewise, an important deadline is September 30, 2021, which is the deadline for making any new UK comparable trademark and design applications, which will keep the same identical details as any pending applications at 31st December 2020. So if your clients are interested in the UK and they have pending applications which were pending at the EU IPO at the end of the year, please make sure they are filed in the UK by this deadline to keep the same details. Again, like all of what we've discussed, if you need any assistance on that, you know where to find us. And finally, as Chris mentioned at the very start, European patents are unaffected by Brexit. We can still act for you in the same way we did before. Nothing's changed, and rest assured we're still a European IP firm. And that is essentially what this slide sets out as well, that we can handle everything in the UK IPO and the EU IPO, new filings, renewals, and we have attorneys based in the UK, France and Germany, which cements our position as a leading European IP firm. And with that, I'll leave the slide here on the screen where we summarize quite nicely how we can help. We can be a partner for you in Europe and handle IP rights for your clients in the UK, France, Germany, at the European Patent Office and at the EU IPO. So that leads me to say thanks for listening today. I'm going to hand you back to John-Paul now, who will moderate any questions that have come in for us. So John-Paul, please.
Thank you, Mark. Thank you, Simone, and thank you, Chris.